Let's talk about creditor debt. And what does that mean? So I'm not just talking about debt you may have on your credit card, or debt you may have because you owe money on your house or your car, etc. When we use the term creditor debt, that typically is something that is thinking about a post-death administration. And that can be post-death administration of a trust or post-death administration of an estate through a will that is being probated. In both of those circumstances, at least in the state of Washington, there are laws that say that if some entity has a claim against the person who died, they need to act. They need to make a claim against the estate or against the trust. And what we often do in either situation, if we're administering a trust or administering a will through a probate after death, is the attorney will publish notice to creditors in the legal newspaper in the county where that person died or where they owned real property. So in Washington, it's a 4-month creditor claim period, and any creditor who is an unknown creditor, so somebody we don't know about, like obviously if it's a credit card company and we're getting credit card bills, they're called a reasonably ascertainable creditor. We know they exist, but if it's somebody we just don't even know about and the personal representative or the successor trustee has no idea that there's a debt out there, and they shouldn't know, they're not reasonably ascertainable, the notice to creditors will provide for a 4-month period to extinguish that creditor debt claim if that creditor doesn't happen to see the notice to creditors in the newspaper. And so their claim is gone. They could bring it later, 6 months from now or whatever, they're out of luck. The other kind of creditor debt claim is what we call reasonably ascertainable creditors. And you just can't publish a notice in a newspaper and not mention it to a creditor that we know about. Instead, we need to give them specific notice. And if we've given them specific notice, they have 30 days up to that 4-month period to file a legitimate creditor's claim with support. And they've got to dot their I's and cross their T's and do it right. Because if they don't do it, then their claim is extinguished as well. So either in a trust administration following a death or in a will, probate, estate administration, there is a very robust procedure for extinguishing creditor debts that don't need to be paid. And that is one of the benefits of making sure that if a death has occurred, that you are going to be working with an attorney to maximize the amount of assets that will be distributed and protect the person who is in charge of making that distribution, because if they didn't do it correctly, they could be liable to the beneficiaries of that estate because they didn't do what they should have done. And a creditor, comes up and says, no, I'm entitled to be paid. The personal representative has already distributed out the money and the creditor has a legitimate claim. So what's the personal representative do? Claw back the money that's already been given to the beneficiaries and likely spent? No, personal representative is likely going to be liable for that claim. So one of the jobs of the attorney is making sure that a personal representative, executor, successor trustee, that they are protected from any creditor's claims that could have been extinguished. See your estate planning and elder law attorney.